Hi, Madam Justice. Thank you for taking my question. You mentioned the Jordan decision. I guess maybe if it's possible, if you could expand a little bit on that. Is the Jordan principle, I take it you're still in effect right now, that hasn't been suspended, or can you talk about, maybe expand a little bit more on your comments?
Sure, happy to. The Jordan decision did provide for exceptional circumstances that are beyond the control of the Crown, the court, the defense. And it's my view that we are in that circumstance right now with the prescription on having congregations of more than 50 people in any given courtroom, and even I think we're down to 15 in locations, which would prevent us from holding jury trials, because if you count the number of jurors needed in a jury trial and you add counsel in the court, you're already at 15. So in that exceptional circumstance, my view is that the clock is not running. However, the challenge will be once we are back in gear, in quasi-normal circumstances, and there is some uncertainty as to how long we will have as individual courts to move towards getting matters on for trial. So that's why I've opened up this discussion about remote hearings that, in my view, can be done in most cases. For example, in a situation of a sexual assault charge, if the charge involves a young child in this province, generally that evidence will come into the court by way of video. And so we already have a remote element to that particular hearing. If there is consent to having the accused appear by CCTV and subject to cross-examination by CCTV, if the accused gives evidence on his or her behalf, then it's possible to run even trials in this new remote context, and therefore work actively to deal with our Jordan problem. Because obviously I make no bones about the fact that the Jordan problem has gotten worse, because we've had to adjourn a number of criminal trials over this period of March 16th rather to May 1st. I hope that helps clarify, Jordan. Good.
Thank you.
Can we stop for 1 second? It's Tony Lay here. We've noticed that Dino Batos is on this. Can that be explained?
That Saudi Arabia and Russia might come to their senses, because this is costing them an awful lot as well, and that the United States might in some way influence.
Let's return to the questions, perhaps. I'm not hearing you, Tony.
Sorry. Let's go to Sarah Ryan, please.
Sarah Ryan with Global News. We heard about some cuts to justice, obviously, before this happened. Can you talk at all about whether those cuts are impacting you guys right now in the work that you're trying to do?
I think that I would probably leave to justice officials where their stats are. In terms of our court, we're doing fine. We worked through our budget issues with the minister before the pandemic hit in a real way. And at this stage, with obviously the suspended hearings, we are at a lower ebb in terms of what matters we're dealing with. But I do foresee that we will be able to conduct matters remotely efficiently. But I would leave any, the cuts on the justice side for response by them, because we're divided. In terms of the administration, we have Queen's Bench Justice, which is administered by me, and then there's Queen's Bench Administration, which is administered, of course, by the minister. And that side involves the clerks of the court, etc. My side, so to speak, involves the judicial staff and our masters.
Janice, could you go next, please?
My mic's not working.
I hear you.
can hear me?
I can.
Oh, good. Okay, thank you. Madam Justice, thank you very much for doing this. There are other provinces, other courts in other provinces that have taken judicial notice of the pandemic when it comes to granting bail or early release. As yet, we haven't seen anything definitive or on the record here in Alberta. Do you anticipate that that will be coming? And if and when it does, will a publication ban be lifted so it can be reported by the media?
All good questions, Janice, thank you. We had, in that criminal law scrum that we had last week, there were matters raised about how the Crown is going to deal with bail reviews. And it was a very cooperative meeting in the sense that there was an acknowledgement by the ADM in charge of Crown prosecutors that really there should not be a need for defense counsel to show a change of circumstances, which is the usual step that is taken in order for the court to hear a bail review in Court of Queen's Bench, because it's a form of appeal, except for in cases such as the murder is the prime example, where this court is the first court to hear bail. In most other matters, then it is the provincial court that hears bail matters, and we sit as a court of review. So it was made clear to Crown prosecutors throughout the province by this directive that the Crown would not raise a jurisdictional impediment to our court hearing bail reviews. So that paved the way for our court to continue on in its work, and we're actively hearing bail reviews during this time. There are decisions that we're aware of from other provinces. I'm aware of one recently issued, I believe on Friday, by a member of our court. And we are obviously very aware of what the jurisprudence is that's being developed in other provinces. For example, there are 3 grounds for consideration by a judge on a bail review. They call them the first, second, and third ground, and it's been recognized that pandemic circumstances may well be part of that third ground. That has been a consideration in other provinces, as well as a decision recently issued in this province. As to the publication ban, my understanding on the one on Friday, Janice, and I stand to be corrected, is that it was dealt with by way of initials. And in that sense, then, I think that there should be access to the judgment shortly. Next question.
Matthew Black from CTV.
Hello, Madam Justice. I was just wondering if you could talk a bit about how this has affected your workflow kind of thing. What have some of the challenges been working more virtually as opposed to being there in person?
Well, I have spent some time at the courthouse here because my presence and the presence of the Associate Chief, I think, are crucial to dealing with things that are arising on a daily basis. And essentially, I guess it feels a little bit like whack-a-mole sometimes. And we are putting out some brush fires. And that's why I think it is good for for us for a period of time that I think is close to an end for us to be on the scene. But I think that, well, I should tell you also that there are 5 judges in Edmonton. We have a staff of judicial assistants who are working actively from home, as are our legal counsel, dealing with any number of issues as they arise. For example, can we sign orders electronically, looking in the law in that area? Case management counsel, etc. So this place is a bit of a lonely place, I got to tell you, Matt, because there's really very few people around. I get into my car in the morning, I drive to work, I get into the parkade. There is the Purell in the elevator, and I walk down to my office where there's just nobody around except for the occasional visit by those who are emergency judges, roster judges, who are keeping a very respectful distance from all of us. And so It is a different world. I don't think I've had a chance really to reflect on it a lot because we want to try to keep ahead of the wave, and we want to really convey the message that we would like to extend our services as soon as possible, and we'd like the bar to join with us in that endeavor. That is, working actively from home so we can get these, get into this new age. And if it's going to last for months, we've got to adapt, and we want to do this sooner rather than later.
All right, thank you very much.
Next up, we're going to switch to a little français. It's Danielle Cadjo from Radio-Canada.
Est-ce que vous m'entendez?
Oui, oui.
Ok, parfait. Je voulais savoir, en se basant sur les actions que vous avez prises depuis le milieu du mois de mars, quelles sont vos priorités présentement pour continuer de faire avancer vos dossiers?
Ben, je pense que ce serait très important de construire le plan, Daniel, pour les semaines qui suivent. Parce que je pense qu'on a déjà parcouru un point ou un temps très important où on a vu la suspension de nombreuses causes, sauf les causes urgentes. Et maintenant, on essaie de vraiment ranimer la Cour, mais d'une façon différente. Et dans ce sens, je crois que tout est possible et que surtout pour les procédures qui ne devront pas être enregistrées, par exemple les pré-procès, les sessions de résolution de disputes, etc., que la Cour offre, mais sur une base informelle. Je pense que c'est ma préoccupation, c'est vraiment d'ouvrir les fenêtres maintenant, mais de façon virtuelle à la Cour pour donner accès. Parce qu'on sait que le monde souffre à l'extérieur. Les familles ont besoin de l'aide de la Cour, l'assistance de la Cour dans ces temps. Et c'est notre rôle de rendre justice de façon efficace et efficiente. Et c'est vraiment mon objectif pour le moment.
Une question qui est liée, si vous me permettez. Comment vous gérez ça avec des dossiers où, par exemple, il y a des clauses comme la clause l'arrêt de Jordan? Est-ce qu'à ce moment-là, il va y avoir un impact sur ces dossiers-là au niveau du délai de traitement?
Je pense que j'ai répondu un peu à cette question avant pour décrire une période maintenant qui serait considérée comme exceptionnelle de mon point de vue. Mais ce qui suit, c'est quand les activités de la Cour seront plus normalisées, qu'il faudrait à ce moment-là prioriser ces causes-là, ces causes criminelles, où il y a un échéancier qui est troublant. Et on a tout à fait l'intention de le faire. Mais avec certains instruments, comme les conférences au préalable, qui rejoignent juges et avocats pour essayer de voir s'il y a une résolution à l'amicale, en effet, qui puisse être négociée et amenée en cours pour la résolution de l'affaire.
Merci.
Merci.
Next up is Johnny Wakefield from Edmonton Journal.
Hi, Madam Justice. Thank you for taking my question. This may be a bit of a hypothetical at this point, but I wanted to ask a question about how you believe the court is going to approach time served. I know, for example, we've heard from some inmates in the Edmonton Remand Center who are currently on general population, but they're locked up for 23 hours a day with a roommate. I'm just wondering if that would impact kind of a judge's calculus on how to award credit for that, because that's obviously not a situation that they would be in if it weren't for this pandemic.
Well, the court has, Johnny, any number of tools to look at the individual circumstances of the offender. And if evidence was presented as to an unduly harsh situation that is existing in detention circumstances, those are things that the court could be advised of and consider. Obviously, that evidence needs to be presented, and judges would not necessarily take judicial notice of a 23 or out of 24-hour lockup. We're also, we had a discussion with the Crown and the defense over various ways that the detention population can be reduced for those cases that really fall on, if they were resolved, they may well result in a conditional sentence order with a confinement to home in the community, as opposed to, for example, a period of detention of 30 days. There might be other opportunities that present themselves in this context in pandemic time to be creative in sentencing. And so we had a discussion with Crown and Defense to have them consider those kinds of options. But I've got to tell you, Johnny, that every case is individual, and we've got to deal with each one on its own individual merits and on the basis of the evidence presented. Hope that's helpful.
Janet Pruden from the Globe and Mail, are you there on the telephone? Jana, are you there?
Nope.
Bill Graveland from Canadian Press, can you hear me? Can you go ahead? I just texted him. Bill Graveland, are you there?
I think he needs to unmute his mic.
I'm hearing he needs to unmute his mic.
Yeah, I'm texting him again.
I think he may have an audio problem. He did join us a little late and we weren't able to check his audio beforehand.
Could he text you the question?
Bill, are you there? I had muted him on my end.
Yeah, I think he has an audio problem on his computer, Tony.
I think that was everyone that we then had set up, unless we could open it up to everyone if there was any other follow-up questions, or if you had further things to say.
I just want to let Bill know too that in that link that I sent you, you know what, I'm going to send you a different link. It does have a phone option. You can try that. I'll forward you that, okay? Thank you. Tony, I need to take control of the room for a moment, please.
Before you do that, Terry, I did get an email from him saying he didn't get that email either.
The second and third one? I sent 3 in the end. Did you get any of my emails?
You take over and I'll try to phone him.
Thank you, Tony.
Perhaps just a suggestion, I've done this in other virtual press conferences. We can all see him writing. If he can just write his questions in, maybe someone can just ask it for him. I'll read his question if that's okay.
Sure.
Bill just said, I wanted to know how concerned the Justice is about delays in the court system.
I missed
Address that a bit.
I missed that. I'm sorry, it kind of broke up. So could you read it again?
I think we've already addressed part of it, but he said, I just want to know how concerned Justice is about delays in the court system and what will be done.
Right. Well, I guess his question is referring to how concerned the court is about delays in the justice system. And obviously we're very concerned. This has been something that is not new for us, the idea of having delays. There were judicial appointments that were delayed to our court. These are federally regulated appointments. That is, we are appointed to this court through the federal government, and there were a number of positions that needed to be filled that took a couple of years, 2 to 3 years to fill. And so that contributed to the court getting behind in many of its criminal matters and also civil matters, with lead times that I actually don't even want to discuss on camera, because we really needed to batten down the hatches. So yes, we're very concerned, but we also have this new benefit of being able to work remotely, and we are confident that over the next several months, with the assistance of the ministry in terms of increasing our IT capacity at lightning speed to be able to deal with matters more efficiently. That paired with the criminal code amendments that allow us to work remotely in criminal matters, I think is going to make a big difference. But we are concerned, and it's certainly why I want to move our ship further out of the harbor we've been in for the last 3 weeks into the less urgent matters, more actively in criminal matters where matters can be disposed of summarily, clearing the decks for what will be a time when we're going to have to prioritize our criminal trials and our criminal in custody matters. So I hope that clarifies what our concerns are.
There's a second question from him, I'll read it out. It says, secondly, is she, I guess that's you, Chief Justice Moreau, concerned about future jury selection? I've talked to advocates who say future jurors might be afraid to be in close proximity to others or about job security to be released for jury selection.
Right, that's a good question. We're going to take guidance from the Chief Medical Officer in terms of when gatherings of over 15 people in one location are permitted. We're not going to issue jury notices until we know that that is a safe place for juries, their jury rooms, the courtrooms, etc. And I think that in the circumstances, we do hear from jury, members of a jury panel if they have special issues that are employment related or health related, et cetera, that would prevent them from sitting on a jury. And so I think the issue is a real one for people just returning to employment. We've also been active in suggesting to Crown and Defense that if there are ways to consider re-electing to judge alone, and the Crown agreeing to that, if that re-election is coming a little later in the game, the Crown needs to consent to it. But in these difficult times, the Jordan waters that we are in right now and trying to plow through, as well as the pandemic, I'm hopeful that consideration would be given by the bar to bringing down the number of jury trials we have. But certainly those will not proceed until it's safe for the public to come into our courthouse.
Hey, Chief, I think that is everyone, as I said before, unless anyone wants to jump in with a final question, I think we're done.
Yeah, I had one or two, Tony.
Who am I speaking to?
This is Johnny Wakefield again.
Yes, Johnny.
Yeah, I'm just wondering, you've mentioned all of the technical innovations that have kind of come about as a result of this. I know lawyers are particularly ecstatic about e-filing. You had mentioned, I believe you said that something along the lines of after this is all over, it won't be going back to the way things were. Do you foresee that happening? I mean, are these things like e-filing and other innovations going to have to stick around after all of this?
Oh, definitely, Johnny. And I guess what I'll have to do is correct you initially. What we're in right now is an email filing age, and that's not e-filing yet. But we are hopeful that we're going to have an e-filing platform very quickly, because as you can anticipate with email, unless it can go into a virtual file with the court, and that file has to be held and managed by a platform, that would be able to have that capacity. Email is advantageous to the bar, but less to the court. And so, yes, once we are certainly heading in the direction of e-filing over the next several months, and it's not something I'm going to give up, because it's going to increase the ability. The moment you take away paper, Johnny, you increase the efficiency of the court. We as judges will have the entirety of a court file at our fingertips, previous orders, etc. Members of the public in the bar will file their documents electronically, and not need to visit the courthouse. The staff can be redeployed that's right now on the front lines of our clerk's offices, taking in paper, putting files away, paper files away, retrieving them for court applications. All that would disappear when we have e-filing. And so then we can redeploy our staff to other very useful functions in an electronic age. So that part is a positive. I really certainly understand that it's on the back of a very unfortunate situation that has created urgency. But we do intend to move fully into remote zone and adjust our practices, which I think will really help with delays in the court system.
Chief, we're going to do one final question. Janice Johnson had a follow-up. Go ahead, Janice.
Thank you very much. We've heard of cases of positive tests within the City of Edmonton staff, within the Edmonton Police Service. I'm wondering what the health of the judges, justices at all three court levels is.
Oh, thank you for asking, and I think we should include in that our judicial staff. We've got over 100 employees who work on the QB justice side. We also have a number of people on the front line, clerks who are very, very important to the administration of justice. But in answer to your question, we moved our judges and most of our judicial staff off-site to their homes with their computers very early. They are essentially self-isolating, and as I mentioned, Janice, we only have about 5 people, that is 5 judges in each of Edmonton and Calgary, and 1 in Red Deer, 1 in Lethbridge, to deal as justices in our hub areas with matters that require, at this point, people to be at the courthouse. And I'm speaking there of bail reviews and emergency protection order matters. But we really are moving to a stage where most of this, if not all, can be done remotely. We had an experience actually the week before last in Calgary where one of our commercial practice group judges heard a commercial application worth several $1 million in the privacy of her office. It joined remotely to the courtroom where only the clerk was present, and several lawyers, a good number of lawyers, by telephone. And so we, I think that may have been a WebEx, I'm not sure, a video application, but in any event, these types of things are very possible. So I think that the health of the people who are close to our court is being protected by keeping them outside of the courthouse. We've given them very specific directions that if they're feeling any symptoms, that they follow the routine, the process that has been established by the Chief Medical Officer, and that is to dial 811 and obtain instructions from Alberta Health Services and follow all of their requirements. So I'm really hopeful that we're going to continue to keep our folks very healthy, and I'm also hopeful that we can remove more people from the courthouses houses of the province as we become more adept remotely.